So we go back to jurisdiction. We're done with the courts, but we will look at the jurisdiction in terms of the general principles in civil procedure. Okay. Okay. Uh, Next topic would be the aspect of jurisdiction. Uh, Under this topic, there are four, but we'll discuss first jurisdiction over the parties. So when we look at jurisdiction over the parties, it refers to the power of the court to make decisions that are binding on persons. Jurisdiction in personam is the power which the court has over the defendant's person and which is required before a court can enter a personal or an in personam judgment. So how it is acquired? Jurisdiction over the plaintiff is acquired by his filing of the complaint or petition. Remember, plaintiff is the complainant. Defendant is the one being accused of. Okay. So the payment is required uh, of required docket fees. By doing so, he submits himself to the jurisdiction of the court. Jurisdiction over the person of the defendant in civil cases is acquired either through one, service of summons, or two, voluntary appearance in the court and submission to its authority. Remember, service of summons and voluntary appearance. Note, a person not within the jurisdiction of the court is not bound to the judgment of the court. Two, voluntary appearance of the defendant. The court may acquire jurisdiction over the person of the defendant without the service of summons, or despite a defective service of summons, jurisdiction is acquired when the defendant voluntarily appears in the action. The defendant's voluntary appearance in the action shall be equivalent to service of summons. Section 23, Rule 14, also of the Rules of Court. To constitute a voluntary appearance, it must be the kind that amounts to a voluntary submission to the jurisdiction of the court. Submission to the court's jurisdiction takes the form of an appearance that seeks affirmative relief, except when the relief sought is for the purpose of objecting to the jurisdiction of the court over the person of the defendant. Under the old rule, the exclusion in a motion to dismiss of the other grounds, aside from lack of jurisdiction over the person of the defendant, shall not be deemed a voluntary appearance. However, under the new rule, the inclusion in a motion to dismiss to the other grounds, aside from the lack of jurisdiction over the person of the defendant, shall be deemed a voluntary appearance. Okay. Uh, So when required, jurisdiction over the person of the defendant is required only in an action in persona. Jurisdiction over the person of the defendant is not a prerequisite in an action in rem and quasi in rem. An action in persona is an action against a person on the basis of personal liability. An action in rem is an action against the thing itself instead of the against the person. An action quasi in rem is one written wherein an individual is named as a defendant, and the purpose of the proceeding is to subject its interest therein and obligations in the lien burdening the property. In the action in personam, jurisdiction over the person of the defendant is necessary for the court to validly try and decide the case. On the other hand, in a proceeding in rem or quasi in rem, jurisdiction over the person of the defendant is not a prerequisite to confer jurisdiction on the court provided that the court acquires jurisdiction over the rest. However, summons must be served upon the defendant not for the purpose of vesting the court with jurisdiction, but merely for satisfying the due process requirements. Objections. Under the new rule, if the court has no jurisdiction over the person of the defending party, the defendant shall raise his or her affirmative defenses in his or her answer. Failure to raise the affirmative defenses in the earliest opportunity shall constitute a waiver. Next, jurisdiction over the subject matter. Jurisdiction over the subject matter is referred to as the power of the particular court to hear the type of case that is then before it. How is it conferred? Jurisdiction over the subject matter is conferred by law, which may be either the Constitution or the statute. As a consequence, since jurisdiction over the subject matter is conferred only by the Constitution or by law, it cannot be granted by the agreement of the parties. And two, acquired, waived, enlarged, or diminished by any act of omission of the parties. Conferred by the acquiescence of the court. Simply stated, there is a lack of jurisdiction over the nature of the action, where the type of action is reposed by law in certain other courts, or in the present case. In a quasi-judicial body, even there may be subject matter jurisdiction. It is well established that the jurisdiction over the subject matter, like that over the nature of the action, is conferred by law and not by the consent of the acquiescence of any or all of the parties, or by erroneous belief of the court that it exists. Hence, the doctrine of the law of the case cannot be applied to serve as a bar against jurisdictional challenges involving the subject matter or the nature of the case. It cannot be applied so as to grant jurisdiction, which the law itself does not confer. RCBC versus Blast Print Industries. So how is it determined? While jurisdiction is conferred by law, jurisdiction is determined by the allegations in the complaint, as well as the character of the relief sought, the nature of an action, as well as which court or body has jurisdiction over it, is determined based on the allegations contained in the complaint of the plaintiff, irrespective of whether or not the plaintiff is entitled to recover upon all or some of the claims asserted therein. Captions of the case is not controlling. The cause of action is in a complaint is not what the designation of the complaint states, but what is the allegation of the body of the complaint defines and describes. The designation or caption is not controlling more than the allegation in the complaint themselves are. For it is not even in an indispensable part of the complaint. Note, the court shall not consider the material allegations in the complaint and not inquire into the truth of such allegations. The amount awarded does not determine jurisdiction. Jurisdiction does not depend on the amount ultimately substantiated and awarded by the trial court. Thus, where the complaint seeking the payment of 1 million is filed within the RTC, but After considering the evidence presented, the court rendered a judgment of 300,000, an amount within the jurisdiction of MTC. If illegitimately filed, the RTC does not lose jurisdiction over the action. It therefore has the authority to render judgment of 300,000. Riano, it is submitted, however, that the above rule does not apply in reverse. The, the defenses in the evidence do not determine jurisdiction. The court's jurisdiction cannot be made to depend upon defenses set up in the answer or in the motion to dismiss. Jurisdiction is based on the initiatory pleading, and the defenses in the answer are deemed irrelevant and immaterial in the determination that while the allegations in the complaint make the case for forcible entry, where tenancy is averred by way of defense and is proved to be the real issue, the case should be dismissed for lack of jurisdiction, as the case should properly be filed with the Court of Agrarian Relations. Law which governs jurisdiction. Jurisdiction being a matter of substantive law, the established general rule is that the statute in force of the time of the commencement of action determines the jurisdiction of the court. Objections to jurisdiction over the subject matter. The earliest opportunity of the party to raise the issue of jurisdiction is in a motion to dismiss filed before the filing or service of an answer, because lack of jurisdiction over the subject matter is a ground for a motion to dismiss. Again, the earliest opportunity of a party to raise the issue of jurisdiction is in the motion to dismiss filed before the filing or service of an answer, because the lack of jurisdiction over the subject matter is a ground for a motion to dismiss. Note, under the amended rules, a motion to dismiss is now a prohibited motion. But one of the exceptions provided is the ground of lack of jurisdiction over the subject matter of the claim. Section 12, Rule 15. Moreover, the amended rules lack of jurisdiction over the subject matter is also an affirmative defense which can be raised in, in a defendant's answer. Section 12, D, Rule 8 in relation to Section 5 and Rule 6. Jurisdiction over the subject matter may be raised at any stage of the proceeding, even at the first time on appeal. Exception. Effect of estoppel, objections to jurisdiction. While it is true that the jurisdiction over the subject matter may be raised at any stage of the proceeding, since it is conferred by law, it is nevertheless settled that a party may be barred from raising it on the ground of estoppel. Tiham versus Sibong Hanoy. Estoppel by laches may only be invoked to bar the defense of lack of jurisdiction if the factual milieu is if analogous to Tiham versus Sibong Hanoy. In Tiham, this court ruled that the long delay of the raising lack of jurisdiction is unfair to the parties pleading laches, because he or she is misled into believing that this defense would no longer be pursued. A delay of 15 years in raising questions on subject matter jurisdiction was appreciated by the court as estoppel by laches. In summary, Tiham applies to a party claiming lack of subject matter jurisdiction when there was a statutory right in favor of the claimant. The statutory right was not invoked. An unreasonable length of time lapsed before the claimant raised the issue of jurisdiction. The claimant actively participated in the case and sought affirmative relief from the court without jurisdiction. The claimant knew or had constructive knowledge in which forum possesses subject matter jurisdiction, which forum possesses subject matter jurisdiction. Irreparable damage will be caused to the other party who relied on the forum and the claimant's implicit waiver. Effective lack of jurisdiction over the subject matter. One, the court may dismiss the case. Two, the court is void. That the judgment is void. If the subject matter is too collateral, uh, if the jurisdiction defect is apparent to the face of the record, it may be subject to collateral attack. The judgment is no judgment at all. Omnibus motion rule. Under the omnibus motion rule, a motion attacking a pleading, order, judgment, or proceeding shall include objections uh, then available and the objections not so included shall be deemed waived. So, exceptions, there are certain defenses which are not waived, even if not invoked in the motion to dismiss. Lack of jurisdiction over the subject matter, litis pendentia, lex judicata, and prescription. Third would be jurisdiction over the issues. Jurisdiction over the issues is the power of the court to try and decide issues raised in the pleading of the parties. How is it conferred and determined? Generally, jurisdiction over the issues is conferred and determined by the pleadings of the parties. The pleadings present the issues to be tried and determined whether or not the issues are facts or of law. Jurisdiction over the issues may also be determined and conferred by stipulations of the parties, as when in the plea trial the parties enter into stipulations of facts and documents or enter into an agreement simplifying the issues of the case. Section 2, Rule 18, Rules of Court. Jurisdiction over the issues may also be conferred by waiver or failure to object to the presentation of evidence on a matter not raised in the pleading. Here, the parties try whether express or implied consent issues not raised by the pleading. The issues tried shall be treated in all respect as if they had been raised in the pleadings. Section 5. No amendment necessary to conform to the authorized presentation of evidence. When issues not raised by the pleadings are tried and the express or implied consent of the parties, they shall be treated in the respect of they have been raised in the pleadings. No amendment of such pleadings deemed amended is necessary to cause them to conform to the evidence. Distinguished from subject matter. The jurisdiction over the issue should be distinguished from jurisdiction over the subject matter, the latter being conferred by law and the former by the pleadings. Jurisdiction over the issue, unlike jurisdiction over the subject matter, may be conferred by consent either of the parties, either express or implied. Although an issue is not duly pleaded, it may be validly tried and decided if no timely objection is made thereto by the parties. This cannot be done when jurisdiction over the subject matter is involved. The last one would be, with regards to this topic, would be jurisdiction over the rest or the property in litigation. Jurisdiction over the rest refers to the court's jurisdiction over the thing or the property which is the subject of the action. This type of jurisdiction is necessary when the action is an action in rem or quasi in rem. When the action is one in personam, jurisdiction over the rest is not sufficient to authorize the court to render judgment against the defendant. In an action in personam, jurisdiction over the person of the defendant is required. Actions in personam are directed against specific person and seek personal judgment. On the other hand, actions in rem or in quasi in rem are directed against the thing or property or status of a person and seek judgment with respect thereto or against the whole world. However, however, in actions in them or quasi in them, summons must also be served to defendant in order to satisfy the requirements of due process. How is it acquired? Jurisdiction over the rest may be acquired by the court by placing the property or thing under its custody. Custodia legis, or constructive seizure. From the institution of the legal proceeding here, wherein under the special provisions of law, the power of the court over the property is recognized and made effective. The extent of relief, any relief granted in rem or in quasi in rem, actions must be confirmed to the rest, and the court cannot lawfully render a judgment against the defendant.